I think it's going to be a different case, Your Honor.
Yeah,
Okay.
I'm not aware that he's in this case, you know.
All right, Tony, we're going on the record on DC 232207, Michael Fisher versus Cheza Hartfield. Counsel, make your appearances.
May it please the court, for the movant, Dick Sales, for Sabady and Company, third-party defendant.
Luke Motley for the defendants, Chester Hartsfield, Keith Franklin, and Reggie McFall, and their tenor plaintiffs as well, you know.
Tony, can you understand what he's saying? It's
very muffled.
yeah, it sounds like you sound like Charlie Brown right now. The rah, 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 rah. I don't know what's wrong with your sound, Mr. Motley.
I do.
Try again.
All right. How about this, John?
Try again. Are you Luke Motley?
Yes.
Okay. I'm not sure what's going on with your sound, but we'll do our best.
How about this, Your Honor? Is it better?
Much
No?
better, much better,
Okay.
much better. Anyone else here on this case?
Yes, Your Honor. Andy Ryan for the plaintiff, Michael Fisher.
All right. And you said Brittany Ransom is here on this case as well?
Your Honor, I'm not sure if she's here on this case or not. I think she just is, I guess, interested in the case and just got out of an arbitration with Mr. Sabady, as I understand.
Okay. All right. Now I understand that there's been an agreement reached about arbitration. Is that right?
Well, Dick Sales speaking. I don't think so. We have moved to compel arbitration. Mr. Motley has opposed it to the extent that it doesn't include all claims. And so we're here to seek an order compelling arbitration pursuant to the agreements at issue here. And there is no agreement.
And Your Honor, I guess I think he's right that there is no agreement. I'm not opposed to the arbitration, but it needs to include Mr. Fisher as well and the claims related to the division of the settlement proceeds. I don't have a problem if the court wants to do that and then stay the case as it relates to Mr. Fisher's claims against my clients related to money that may be owed on from loans and certain things like that.
All right, let's take a step back. I'm trying to so Mr. Sales, you're moving for arbitration on just some of the claims, is that correct?
I'm moving for arbitration on only the claims that are subject to the arbitration provision in the contracts with the clients who are now the respondents and the defendants in your case. I may refer to them as the co-relators, which they were in the Ketam case. I may refer to them as the defendants, which they are in your case. And I may refer to them as the respondents as they are to this particular motion. But we are seeking to compel the co-relators' claims that they have asserted against Sabady and Company to arbitration and not the other claims.
Okay, so what I said at the beginning was correct, that you're only trying to send some of the claims to arbitration, correct?
Yes, the claims that are arbitrable, only those.
Okay. And Mr. Motley, you want to send all of the claims to arbitrate?
I want to send the claims related to the distribution of the settlement proceeds, which would be claims against Mr. Sabady and Mr. Fisher.
Mr. Motley, okay, and both of you guys work on this, okay? Mr. Motley, so am I correct that you want to send all claims to arbitration or different claims to arbitration than Mr. Sales does, or additional claims? Kind of tell me your position, because it was not clear in your briefing.
Well, my position is, and if I may, this is a dispute over the distribution of a $14 million False Claims Act settlement. The distribution, as I understand it, is governed by 4 agreements that the co-relators made with Mr. Sabady and by 3 agreements, sharing agreements that the co-relators made with Mr. Fisher. I believe that all of those claims related to those agreements need to go.
Okay, so I'm just trying to get a lay of the land at this point. So you have the co-relator claims or the claims against the co-relators, and then you want to compel it. You're okay with those claims going to arbitration, am I correct? Just those claims?
Yes, as long as Mr. Fisher as a co-relator.
Whoa, just a second. Are you okay with those claims going to arbitration? The claims that Mr. Sales want to go to arbitration?
Only if those include Mr. Fisher as a co-relator.
Okay, so what you're saying is that you want those claims and additional claims as well to go to arbitration, correct?
Well, I guess this may clear it up because Mr. Sales referred to claims against the co-relators. And if he's including Mr. Fisher in as a co-relator, then yes, I agree, those all need to go.
Mr. Fisher,
Fisher was the relator. He was not a co-relator.
Okay. So I'm just trying to, so if I understand this, and I'm not trying to get you to argue the case.
Yes.
That Mr. Sales wants some claims to go. You're okay with those claims going, but you also want additional claims against Mr. Fisher to go to arbitration as well. Is that kind of set the stage for where we are?
It sort of does, Your Honor, because we're talking about a declaratory judgment claim, which would include the interpretation of the agreements of which Mr. Fisher is a party. A necessary party.
All right. So I understand what the difference is on the arbitration. So let's hear that argument. Why, whether or not Mr. Fisher should be included in the arbitration. Did Mr. Fisher sign the arbitration agreements?
Yeah. Are you talking to me, Your Honor?
I guess both of you. Did he
All
sign
right.
Well,
If you
in
look
that
at-
case, I'll be glad to address that. Mr. Fisher has not invoked the arbitration provision he has with Sabady and Company, nor has Sabady and Company invoked that same arbitration provision that they have with Mr. Fisher. The co-relators are not parties to Mr. Fisher's contract with Sabady and Company, so they can't enforce it. And so that is
Mr. Sales, then I want to make sure I'm understanding this. So
yes.
There's 2 different arbitration agreements or 2 different sets of arbitration agreements. Those between Sabady and Fisher and those between Sabady and the co-relators. You're saying that he doesn't want to go to arbitration on any claims between him and Sabady.
Mr. Fisher has not asserted any claims against Mr. Sabady,
Okay.
nor has Mr. Sabady asserted any claims against Mr. Fisher.
He's not invoking the right to arbitration under that agreement.
He is not, and nor is the firm.
Okay. And as I understand it, the co-relators were not signatories to that arbitration agreement, correct?
That's right. They had their own specific contract individually, each of the 3 of them individually. So there are actually 4 attorney-client contracts, each relator having their own and Mr. Fisher having his own. That is the lay of the land. And so with respect to the claims that have been brought against Sabady and Company by the co-relators, they must go to arbitration. As you know, and I say this with all respect to the court, under the Federal Arbitration Act and under the Civil Practice and Remedy
But
Codes.
Mr. Motley, but I also understand Mr. Motley agrees to that, right?
Well, Your Honor, I think what if I may, we may can clear some of this up. If you've got our supplemental response, it's got all 4 of the engagement agreements with Mr. Sabady, exhibits A, B, C, and D. If you've got those in front of you.
So I just got from Sabady and Company sent by Miss Kim James. I just got a notebook there, and it has the tab number 1 is third-party defendant Sabady Company's motion to compel arbitration, and then tab 2 is Fisher's partial joinder, to the third-party defendants. And then tab 3 is defendant counter plaintiff's response to Sabady's motion for arbitration. And then tab 4 is Sabady and Company's reply. And then tab 5 is counter plaintiff's supplemental response. Is that, which one are
There you
talking-
go, the supplemental response.
All right.
Look
so
at
that's
Exhibit
tab
A
5.
on that document.
Okay,
That should be a May 19th, 2019 engagement letter with Sabady and Company marked as Exhibit A.
I see it.
Okay, that first paragraph, this was the agreement that was signed by Mr. Fisher with Sabady. And if you'll look at the first sentence, it says this letter will acknowledge that Michael Fisher, and they refer to him as a client or you, agrees to engage Sabady and Company, the firm, for the purpose of representing you and other co-relators. Together, they define those as the clients. In the current matters against JP Morgan Chase, which was the settlement, which was the case that was settled. If you look at the second page of that exhibit, item E2, I guess it's the second page of that exhibit, talks about the distribution of settlement funds. And it's item E, and it says funds not distributed to attorneys under the above sections C through D shall belong to the clients. And they've defined the clients as Fisher and the other co-relators, which are my clients. And then if you look on down page 6 of that agreement, paragraph 14, it has the arbitration clause. So this is going to be Exhibit 1, whether we're at trial or whether we're at arbitration. And we believe that this document has to be construed along with my client's documents. And they say the same thing. If you look at Exhibit B, they define us all together. And so that's a document. That's why Fisher is an indispensable party, because that document is going to be germane in the Exhibit 1 to whether we're at trial or whether we're at arbitration. And so to the extent you send the claims, my client's claims against Sabady to arbitration, I think Fisher has to go. And I don't have a problem with that. I'd rather not go to arbitration, but if we go, I think this document requires you to send Fisher as well, because otherwise you're going to end up, whoever the trier of fact is going to end up trying to interpret this agreement. And it's got to be binding on Fisher, whatever the ruling is. Otherwise, we wasted our time.
Judge, may I address that?
Okay.
First of all, with respect to the first paragraph where it refers to clients plural, the reason for that is very clear. If you look at the contract as a whole, it discloses a multiple representation of 4 different clients. It provides for a waiver of conflicts among them, and it provides a mechanism for the distribution of settlement proceeds. So the plural clients in the lead-in paragraph of the Fisher contract does not make these defendants parties to the Fisher contract. And they are not signatories to the Fisher contract. And so they can't invoke its provisions. And I want to point out specifically that the argument being made to bring along Mr. Fisher is that he is a necessary party. I would point out to the court that Mr. Motley did not cite a single authority in either filing that he made that supports bringing in a non-signatory, a non-bound party into an arbitration because they are a so-called necessary party. Not a single solitary authority for that prospect. And so I think that the distinction that he just made is one that doesn't make any difference at all in the analysis. On the second page of the Fisher contract, where he recited paragraph E, that says funds not distributed to attorneys under the above subsections C through D shall belong to the clients. That provision is not in the contracts with these relators, these respondents, these defendants. That is not there. Under their contract, they have no right contractually to any of the statutory attorney fees. So what Mr. Motley is trying to do, and I don't blame him for doing this, he is trying to use the Fisher agreement, to which his clients are not party, to invoke it in some manner to try to bring Fisher into the arbitration. Now, with respect to the conflicting rulings, I submit that isn't correct either, because if the arbitrator finds that Sabatian and Company distributed the funds according to the contracts and did no wrong, that'll be the end of the arbitration. If the arbitrator finds that Sabatian and Company somehow breached a duty or deviated from the proper distribution of the funds under that agreement, then in arbitration, Sabatian and Company will have to respond to that, presumably in damages. So Mr. Motley's argument that we have to have Mr. Fisher in the arbitration to get relief, I submit, is incorrect. And I would say that the arbitration clause itself, which has to be the guiding principle for what can go to arbitration, provides that the arbitration is any dispute concerning any aspect of the firm's representation of the client. That's a quote from the arbitration clause and the scope of the arbitration. And so to bring Fisher and his claims and the other arguments that Mr. Motley made doesn't fall within the scope of the arbitration clause. So we submit that this is a matter in which not only is it required that the arbitrable claims be submitted to arbitration, Mr. Motley has so agreed. He is trying to bring Mr. Fisher along. There is no contract providing that. And the argument that he's making is that there's an inefficiency because he is somehow a necessary party. We've cited a U.S. Supreme Court case, the KPMG case, that holds that even though you have some claims in arbitration and some in court in different forums, and that may be inefficient, that is no reason for the court to fail to order the arbitration. The same thing is true
Mr. Sales, and I feel like I'm shooting a little bit in the dark here. You and I both know, I'm sure Mr. Motley knows as well, is that, and I'm not a huge fan of arbitration either. I think it's overused. I think there's certain situations where it's probably a good idea, but I think it's the strong presumption I've never been in favor of. But I have to follow the law. There are a number of you're right, the general rule is that non-signatories are not bound by an arbitration agreement, but there are exceptions to that. Now, the difficulty is that Mr. Motley hasn't cited any of that law or what exception he's trying to fall under. So my thought on this is I grant the arbitration as to the portion that you guys agree on. If Mr. Motley wants to re-urge his motion, but I feel like I'm shooting in the dark here on what legal basis there is to send a non-signatory to arbitration in this particular case without briefing or without arguing that particular point.
Judge, there's one additional.
Let me I guess address it. I mean, all these arguments about how you construe the contracts and the division, that's all for either you or an arbiter to determine. I mean, I think it's clear that he is a party, or he has signed a arbitration provision, but I understand, I I assumed we had the issue teed up since we were talking about what I'd agreed to do, and I'd agreed to go to arbitration if we all were going. And so I anticipated a ruling from the court, either yes or no. But if the court, I certainly do intend to re-urge my motion to include Fisher, because I think under the law it is the.
And let me ask this, because I guess I should know this, but I just haven't seen it come up. I assume the arbitrator can't just add Fisher. I would need to add Fisher to the arbitration, right?
Well, Judge, actually, if Mr. Fisher tried to intervene in the arbitration under JAMS Rule 11, the arbitrator has absolute authority to determine the scope of the arbitration clause and whether it has jurisdiction over a party under the arbitration agreement.
If he wants to enter, but if he opposes entering it, can they bring him in?
No.
Okay. So I go back to my original ruling. I'm going to go ahead and order the claims that Mr. Sales has suggested going to arbitration. And Brittany Ransom keeps, I guess she's arguing by chat message, but anyway, so we've cleared up that issue. So let's go to the issue of whether or not Mr. Motley needs to be disqualified.
I think, Your Honor, I think you simply ruled on that last time, and I don't think that was re-urged.
Oh, I did. Okay. So that's already been taken care of.
I think so, Your Honor.
Sales.
That's why I'm here.
Well, from my understanding, and I've only seen the transcript, you indicated an inclination, but had not ruled. And of course, I expect you.
All right, I'm going to deny the motion to disqualify Mr.
Okay.
Motley. So let's get orders in place on this. Mr. Sales, I'm going to put you in charge of getting the order on this. Let me tell you about how to do the order, because I've changed this recently. The beginning of the order needs to say that this was heard on July 15th, 2024 over Zoom. I'd like you to share the order with Mr. Motley so he can comment on it. It needs to indicate this two things. One, exactly the scope of the arbitration and what claims are being sent. And secondly, that the motion to disqualify Mr. Motley is denied. And I'd like to get that, if possible, by this Wednesday.
We will do so. Yes, sir.
Any questions, guys?
Oh, Your Honor, but I am free to re-urge or to bring a motion to add Mr. Fisher to the arbitration.
Mr. Motley, let me, I know you don't practice, I don't know how often you practice in Dallas, but the way I look at these things is when I first started as a judge, I would occasionally not send cases to arbitration because I don't like arbitration, and I got reversed a few times for that. Decided that wasn't a good idea. So I'm very strict on following the law. You got to tell me what law you're relying on. And so if there are cases that would require Fisher to be brought in, and I know there's exceptions to allow non-signatories to be brought in, I want to look at that. But if you just file another brief without case law, without support, we're not going to get anywhere. And I would not.
I understand, Your Honor, and I apologize.
That's all right. You guys have a great rest of your day. Get me that order by Wednesday, okay?
Very good.
Thank
Yes,
you.
sir.
And
Thank you.
e-file it and email it as well.
Okay, very good.
I don't know what this Miss Man, I don't know if she's just providing. Anyway, that's interesting. She keeps providing little commentary. All right, our next hearing is TC Fuels versus Shatnawi. I think we're ready for that. Is everyone here for that?
Yes, Your Honor.
Yes, Your Honor.
I'm here, Your Honor.
All right. Let's go on the record on DC 2217695. TC Fuels LP versus Shatnawi Inc. Counsel, make your appearances.
Your Honor, Lauren Upshaw here for Movements, Shatnawi Inc. and Allah Shatnawi.
John Barry on behalf of TC Fuels LP.
Drew Siegel on behalf of Mr. Kabir and Gramson.
Todd Shadle, representing Petroleum Distribution.
All right, let's proceed.
Yes, Your Honor, this was brought on my client's motion. There was some disclosure that was brought to my attention. Initially in this, I had requested that just some background. In the plaintiff's expert disclosures, which were given on the last day, they did not meet the technical requirements of Rule 195.5 with regard to their expert disclosures. In those disclosures, they listed all of their employees as experts, and they included another person named Stanley Thompson as an expert. None of these disclosures met the requirements of 195.5. I did state in my motion that they had not disclosed the employees previously at all, just as basic fact witnesses, and that they were trying to get an end run around that failure by designating them as experts. It has come to my attention that is not the case. And so we're just merely seeking to strike the employees as expert witnesses and to strike Mr. Stanley Thompson as an expert witness and a witness altogether. Quite simply, in the plaintiff's expert designation, they just make a list. It's Exhibit B. They list all of their employees and then state that they will testify as experts to basically the facts asserted in their petition. They provide none of the items required by 195.5 in terms of reports, data compilations, anything like that. And furthermore, none of the things that are testified to require an expert to testify to them. With regard to Mr. Thompson, they really provided none of the information. They state merely that he is an expert retained by the plaintiff, and he is the former president of Pruitt Petroleum Products, which is a fuel distributor for many years. None of that other documentation was provided, and so we are asking for the court to strike him as a witness and to limit the TC staff's statements to matters of fact and not matters of expertise.
May I respond, Your Honor?
Hey.
I represent TC Fuels LP. First of all, with respect to the disclosure of Stanley Thompson as an expert, that disclosure was made. A storm ripped the roof off of my office building on June 3rd, and I was unable to get a written report or to further comply with the requirements. So I am satisfied that because of that, I will not have him as an expert witness in this case. With respect to the employees of TC Fuels, not all of the employees of TC Fuels are listed. The ones that have involvement in running the business and have had involvement in running the business for years should be able to testify not only as to facts, but expert witness on how the fuel business is run. And that would be the only reason they would be asked expert witnesses. I do not want any party, any of the defendants, to be able to object to testimony with respect to usual and customary acts and conduct in connection with the fuel supply business when I proffer their testimony for that purpose. This is a case dealing with a written fuel supply agreement, the potential obligation of an assignee with respect to that agreement, and the claims against a third party, another fuel distributor, who entered into an agreement on the property that we believe was subject to an existing fuel agreement at the time. So we have combined fact and expert witnesses, but their expertise is only limited insofar as the usual and customary means of operating the fuel distribution business. None of these parties have been noticed for depositions, and they were the same parties initially disclosed as witnesses. And in the first disclosure that was made some time ago. That disclosure has also been amended prior to the deadline date. The initial disclosure was filed.
So let me make sure I understand this. So there's the designations that of these a group of employees that you've made, does it indicate how they're experts and what their expert opinion is?
No, it doesn't, Your Honor. The roof blew off and I was unable to get any more done on this. I can supplement, of course. But it does say, go ahead. Ms.
Well, to the extent that that's all that they're going to testify to, I have no objection to these witnesses. It's just when they designate as an expert, that's to assist the court understanding.
I'm going to strike the expert designations. I do want to make it clear in the order of Ms. Upshaw that they can testify about the, what did you say, custom and usage? Is that what you were saying?
Customary operation of fuel supply business, yes.
That they can testify about that. Go ahead and prepare an order on that, Ms. Upshaw. At the beginning of the order, it should say that this was heard on July 15th, 2024 over Zoom. Prepare the order, share it with your opposing counsel, and try to get that to me no later than Wednesday, okay?
Yes, Your Honor.
Thank you, Your Honor.
Anything else we need to chat about, guys?
No, Your Honor.
That's it.
Okay, you guys have a great rest of your day.
You too.
Thank you.
Thanks, Judge. Okay, bye-bye.
Okay, guys. So Tony, just to remind you, we have trial tomorrow. Let me just double check that nothing's changed. That happens all the time. And we have trial on Wednesday, a different trial. Let me see how we're looking on both those. We get surprise settlements all the time. No settlement on the Tuesday case. I don't think we'll have one on the Wednesday either, but let me double check.
Yeah, nothing yet, Judge. Everybody's on.
Nope. Okay, so it looks like we'll have those two trials, Tony. So sorry, but you rest up and we'll see you in the morning. Okay, Tony?
All righty. Everybody have a good one.
Thank you.
I do.
All right, I've gotten some more of the attorneys that are going to be at the different lunches. I don't think I have all of them yet, but I have at least two more, Kirkland and another one came in. So anyone have any questions about anything today? That last hearing, if you guys end up working in a big firm, you are going to deal with the issue of arbitration. That is just, if you do litigation, that is, it's such a common way to just resolve commercial disputes at this point. So, or employment law disputes, or it is really, really spread into a lot of different areas. And so understanding arbitration law is important. So did anyone have any questions about that? Yeah.
Like, while it was happening, but am I right in assuming that Mr. Fisher was a whistleblower in this case? That's why he's like a relator?
I think that's right. It's super complicated. So the way I understand it, you're welcome to read the briefing, is that, so let's say that there is, we'll say, Harrison, you're running a department in the federal government. Okay, let's pick the department. What do you want to run? Oh, okay. Well, department, let's not take the whole, look at him, how aggressive he is. He's taking the entire agency. Let's say you're doing biofuels in the Department of Energy. You're running biofuels and you have a little arrangement with Keegan on the side where you guys, you have a kind of sweetheart deal where he gets special treatment for his biofuel company that other people aren't getting. And Emmy, who's been your longtime friend, finds out about it. And she's like, oh, this is not good. This is probably illegal what they're doing. And she's a whistleblower. But Emmy's not the only one who found out about it. You also have Lily found out about it, and Leanne found out about it, and no one really liked you that much in this hypothetical. And so they all want to blow the whistle on you and Keegan. And the issue, and I'm not an expert on this because this is just kind of based on the briefing. So the issue is, it's first, who gets to the courthouse first gets the biggest chunk of the recovery, I guess. So each of them would hire lawyers to try to whistleblow on Harrison as quickly as they can. And whoever gets, I think, as I understand it, whoever gets there first becomes the relator. And then the additional people are co-relators, and they're going to get a smaller piece of the pie if there's a recovery. That's kind of how I understand it. I am far from an expert in this area. I'll just be honest. But that's kind of how I understood it. And so whoever, say Emmy is first, whoever her lawyer is, if they got to the courthouse first, they would kind of become lead counsel. And if they were splitting up the fees among the lawyers, she would get the biggest chunk of the fees, and then the lawyers for everyone else get less.
So Mr. Motley was representing like big defendant in this case?
That's my understanding.
I guess like my question is, he just wanted Fisher to be included in the arbitration to avoid multiple liability?
That's his argument. But so I don't know if it was clear what I was trying to say, which is generally, if you have an arbitration agreement, and let's say that I'm trying to give an example here. Okay, so we're going to have Harrison be the all-day bad guy here. So Harrison is running, no, Keegan's running his biofuels company, and Kate signs a contract with him to provide I don't know how you make biofuels exactly, cow dung from her ranch, and they have an arbitration agreement. And trying to give a good example here. And then Keegan enters into a relationship with Emmy's company and to process it. So he's kind of the middleman, but he does not have an arbitration agreement with him. And you believe that they're both kind of defrauding you, Kate. So Keegan and Emmy are both defrauding you. You could take Keegan to arbitration because you have an arbitration agreement with him. You don't have an arbitration agreement with Emmy, and she's a non-signatory. And so it used to be the law for a long time was that non-signatories were not bound by arbitration. The Texas Supreme Court has carved out certain exceptions to that where non-signatories can be bound to an arbitration agreement, even though they weren't part of the original agreement. He didn't brief which of those exceptions applied or what the current state of the law is on that, because it's constantly changing. I will say there was kind of a saying that this is not law, but this is kind of something that was talked about. There was an opinion that came out of the Supreme Court. It was kind of shocking when this first started happening, where non-signatories could be brought in, because it did seem kind of, wait, am I still on? Oops.